now call the second case on this morning's docket, case number 118387, Jason Oil Company, LLC v. Frankie Littler et al. Counsel, before you begin, let's give the audience a chance to vacate without disrupting your arguments, so about 15 seconds.
May it please the court. I'm John Richardson, and I represent the Baldwins that is identified as the appellants in this action. This matter comes before this court on a grant of a motion for summary judgment from the Rush County District Court. It involves the rule against perpetuities, that ugly and awful rule that we have all tried to avoid in our careers. And I look back 53 years upon my learning of this rule and was in great concern about my future career. And it took a couple of cups of strong coffee with the students in my class to be assured that it would not be on the bar exam and it would not be on the exam for that class. And here I am 53 years later coming before you on something that I think is of great importance. It certainly is something that originated in 1967 before the adoption of the Uniform Rule Against Perpetuities. A man by the name of Frank Littler, as the grantor, executed 2 deeds for farms he owned located predominantly in Rush County, Kansas. In one deed, he named Ruby I. Myers the grantee, and the Stull appellees are her descendants. The other deed, named as grantee Franklin G. Littler and F&E Littler, LLC, today is the successor to Franklin G. Littler. These 2 deeds are for consideration by this court today. In both deeds, Frank Littler conveyed the surface absolutely, and as grantor, saves and accepts all oil, gas, and other minerals in and under and that may be produced from said land for a period of 20 years, or so long thereafter as oil and or gas and or other minerals may be produced therefrom and thereunder. Frank Littler died, and on December the 28th, 1973, his testate estate was closed by journal entry of final settlement in the Rush County Probate Court. Frank Littler devised the saved and accepted minerals and royalty interest and the residue of the estate to the following named persons in the following proportions, and basically those are 4 children, at 21.13% each, and 2 grandchildren at 7.74%. What I want to talk to you about today is...
Counsel, I hate to interrupt. Bailiff, could you secure the doors or ask the people outside to keep it down, please? Thank you. I'm sorry.
What I want to talk to you...
Since we have a little break here, for my benefit, to simplify this, I've been referring to the Baldwins as representing the interests of the grantors, and the Stulls representing the interests of the grantees. Is that accurate? That the Stulls, we can refer to the Stulls as being successors of the grantees, and the Baldwins being successors of the grantors?
No.
No, okay.
I think the best way to explain it is that the nature of how this lawsuit came about. The plaintiff is Jason Oil Company, who took an oil and gas lease upon the northwest quarter and the east half of a section, I think it's section 20, and that being 2 separate leases because the Stulls own the northwest quarter and F&E Littler LLC owns the east half of the section. There were originally 28 farms that were involved. It was owned by Mr. Littler. And he sat down in 1967 and made a series of 28 separate deeds. And it just so happens that 2 of those deeds are all we're talking about in this action. But this action obviously has some effect upon the other 26. So the Stulls were defendants in this case, as well as the Baldwins. And it looked like that it was just a simple, quiet title action until this appeared on my desk. And when I looked at it and I said, what in the world is this? I hope it's not what I think it is. It's the rule against perpetuities. And so through the filing of various pleadings, we tried to figure out what kind of an interest that it was, and that we ascertained that we were at odds between the Baldwins and the Stulls.
Okay, your clients reserved the mineral interest for 20 years or so long thereafter as oil or gases.
They didn't do it, Frank Littler did all that
Well,
in his deeds.
but that's what they're relying on. They're the successors to that interest.
That's correct.
Okay, and they're on a
During all
term
28
term
of them.
interest. On a term interest is 20. It was 20 years or so long thereafter as oil or gas or other minerals are
Correct.
produced. The 20 years passed, nothing was produced,
On
and
each
ordinarily that would then mean that the other parties in this lawsuit would have had the mineral interest. But you're saying that they do not get that because their contingent interest during that 20 years violated the rule against perpetuities, and so that transformed the determinable term interest into fee simple absolute in the minerals.
Fee
That's
simple
your argument.
absolute, and the grantor and the successors
Okay.
there too. That's correct. And so that's where the mistake comes in the resolution of what the interests are, is it looking only at the grantor's interest and not looking at the grantee's interest. And the grantee's interest of what comes out of that is an executory springing interest. And that's where this court has failed in the past. This is a case of first impression as it relates to mineral interest as opposed to royalty interest. The cases that have been before the court before related to the royalty interest. Rucker is one of those cases that Justice Biles, I believe, authored the opinion upon, and which gets us into trouble in this case, as well as the next case on your docket this morning of Oxy versus Red Wing, that never identifies properly the interest that goes to the grantee. And that's what we're here to ask you to sort out, look at carefully, agree with us that we believe that it is an executory springing interest, regardless of what you read out of the restatement of property third, where it says that there's only 2 kinds of future interest, both of which are not affected by the rule against perpetuities. That's remainders and reversions. But yet here we have the executory springing interest that are impacted by the rule against perpetuities, because it is that contingent thing that is left in Frank Littler's name. So he has a defeasible term interest. There's no question about that.
If we want to cut through the terminology here, it's what I wrote down when I was reading all these briefs a
All 167 pages of it.
weeks ago. I said, what you're arguing for us to do is to give the grantor, Frank, something he never intended to keep. And you want us to take away from the grantee what the grantor, Frank, intended to convey.
Well, you're talking expressly about intent, and of course the rule against perpetuities ignores intent.
But we're talking about the intent of the parties, and so we can at least agree that this transaction didn't intend the result that you're arguing.
That's correct.
Okay.
There's a way to read into it that it is, and you apply the will, and you read the will carefully, and it says he devises these interests to these same people in these 21.13% interest and 7.74% interest. So, yeah, there is a question there, but I'm going to agree with you that that's exactly what the impact of the case is.
And
But what it does is respreads the interest across the whole 28 farms.
And one step further, that not only was the intent of the original parties when it was created, but arguably the grantee paid additional money to acquire the mineral interest in 20 years or whenever. And so you have a defeating of the contract to some extent, that I tried to buy this land, surface, and the remainder in, or a executory interest in the minerals, and I'm willing to pay more for that than if it were severed forever.
No, this has not affected the alienability of the property in any regard as it relates to the family. Nobody's ever challenged
Now,
this.
let me put that another way. The land with contingent interest in the minerals was worth more than the land without the minerals ever. If the severance was forever, the value of the land isn't as high as it would be if there's a possibility to acquire the mineral interest.
I agree with you.
Okay, so not only was it not the intent, but the grantees didn't get what they paid for.
Well, but the grantees never paid anything. When you said they paid them something, they paid them for the right of surface use at $75 a well. And then there was another payment in order to activate all this out of the will of $50,000. I don't know whether that was enforceable or not. You know, when somebody says, I hereby give to my family my property conditioned upon them digging into their own pocket and paying money. I thought wills were to distribute property rather than collect property from, but it's a redistribution, and it was a condition that was fulfilled anyway, if that's what your question goes to.
My
What
question is, if you have a partial interest or an interest of some sort in the minerals plus the surface, is that worth more on the marketplace than if you have only the surface?
I can't disagree with you.
So,
You got more of something than you
where
had
I'm
before.
leading to is that when you talk about alienability, I'm going to talk about marketability. If we agree with you and apply the rule against perpetuities the way you want to, that's going to be a permanent severance of the minerals. And it's a severance of the minerals that impacts the marketability of that land.
Not the marketability necessarily, it's a
Well,
consideration.
sure it is. You're not going to pay the same for the surface
No.
that you would pay for the surface
You're not.
and the minerals.
There's a distinction between marketability and saleability. I don't see the comparison doesn't match to me personally, but I'm trying to do the best I can to answer your question.
Okay.
The whole is not worth,
Well,
the
what
whole
I'm,
is always worth more than the parts.
well,
But sometimes
exactly.
the parts added together can be more than the whole too.
Exactly, and if you, I'm leading up to the policy behind the rule against perpetuities. The way that the sale was structured, there's a possibility that the bundle of sticks would be reunited and that the land would be back to fee simple absolute on all of it. But under your application of the rule against perpetuities, that isn't going to happen. That it will be forever severed, so you will have less than the whole fee, which seems to me to be contrary to the whole rationale behind the rule against perpetuities.
I disagree. It's not against the intent of the rule against perpetuities. It was designed specifically for avoiding dead hand control, to get it back to where it needed to be to begin with. And all of these people that are here before you today are the family of Frank Littler. It goes back to the same people that we get. It just comes out in a different proportion. Now, what I would like for you to look at specifically here, I'm running out of time, and that is the question of what to do about this. And where we stand right now is that lots of courts are going towards let's figure out how to get out of the rule against perpetuities. Let's throw the thing out to begin with. Get rid of the whole mess. I plead with you, don't do that, because that'll create just as much chaos as the chaos that you've been told. Now, where we stand jurisdictionally in this case, as I understand it, is that this case, if you agree with me, has to go back to Rush County District Court. Have to be remanded because there's another issue. That issue is the constitutionality of the uniform rule against perpetuities. And so, when it gets back, that's the time to apply 593405B, which says, if I lose that argument that it is constitutional, then my opponents over here will then be in a position to ask the court to reform it and perhaps do Justice Johnson, which is exactly what you've been asking about, to remarry this back together. So that jurisdiction remains in the district court today. I don't think you have the jurisdiction to make an exception to the rule. I don't think you have any basis whatsoever to deal with coming up with some double deeding kind of a concept that has been used in some states. Professor Pierce has, in agreeing with me, by the way, about the rule here is a springy executory interest. Don't forget that he's come up with some statute of limitations applications and things like that. All of that really belongs in the hands of the district court because we have to consider 77-109 of the statutes. And that says the wants of the people. That's where we adopt common law as the law of Kansas. And in any time of change that we want to go back to 77-109 and look at that, and it says the wants of the people shall be the consideration for the modification of the rule against perpetuities. Any questions?
Do we have any more questions?
Yeah, on the reformation statutorily, is that to reform the deed to comply with the rule against perpetuities?
Yes, I believe it does.
But that still wouldn't get you back just complying with the rule against perpetuities wouldn't give effect to the intent of the parties, because you'd have to.
Well, I think it does say something about the intent of the parties.
So in your instance, what would that look like? That you would reform the agreement to just be a strict 20-year term?
Well, I think that's one of the possibilities that could happen. I think it's pretty broad, but I don't know that anybody's ever used it up to this point.
Yeah.
And if you'll note in the brief, we said that we did a Westlaw check, and executory springing interest is mentioned 37 times is the way we put it in the brief. I've checked it again, and it's now up to 39. That's across the entire breadth of the United States. So all this gloom and doom that's being preached here, if you make the change, why there's going to be chaos in titles to real estate and so forth, I ask you, that's not based upon any fact. That's not based upon any evidence that has gone in here. I will concede that the lawyers of Kansas that practice in the oil and gas patch are upset with me. I've heard my name battered around because, you know, he should be smarter than that in raising these kind of questions. But I, in all sincerity, believe in the rule. It has a place. There is a place in the brief where I mentioned that it can be used in spendthrift trusts, an article by Professor Camp from Texas Tech University. And so with that, I will rest my case.
Do we have any further questions? Thank you, counsel.
Thank you.
May it please the court. Rob Bauer on behalf of the defendant appellees, which have been referred to as the Stolls in the briefs. I'm going to be sharing some of my time with the counsel for the plaintiff appellee, Jason Oil Company, LLC. And an important part of this case was touched on about the effect of this interest and the intent of the parties. And I think that it's accurate to say that what was intended, if the rules applied, what was intended by this deed is not going to occur. And that's also going to decrease the value of the property. We have...
But parties can't intend to violate rules of law, can they?
Well, I'm not sure what they were intending to do at the time. I don't think they
let
were...
me rephrase that. Can two parties to a contract agree to violate a rule of law?
No, they cannot agree to violate a rule of law. I would agree with that.
And we say the rule against perpetuities is a rule of law, then how do we bring the party's intent into play?
Well, I think that's what the history of some of the Kansas cases, more recent Kansas cases, have started to look at interpreting the rule against perpetuities or giving effect to the rule against perpetuities in light of the party's intent and trying to construe that rule or apply that rule in a way that will give effect to the intent of the parties.
But you've just told us we don't know what that intent was here, so how does that play out?
Well, I don't think they intended to violate the rule because I'm guessing they probably weren't aware of the rule. I think what they intended to happen was clearly what was in the language of the deed, which was that the grantor, Mr. Littler, intended to reserve the mineral interest for a number of 20 years, and then if there was no production, that interest would then pass on to the grantee, which my clients are the successors in interest of. And as was indicated, there was no production.
Do you agree that what you just recited is a violation of at least the classic understanding of the rule against perpetuities?
No, because I think you can look at the interest that the grantees received as being vested. It was certain, it might not have vested in possession, but vested in interest at the time of the creation. Possession might not occur until the 20 years or until, if there was production, production would cease. But I think that you can consider that interest a vested interest and then avoid having to worry about applying the rule at all because the rule doesn't apply to interests that are vested.
I've got to be honest here. In reading your brief, I discerned that you were telling us why the result you want is good and telling us ways in which we could get there. And that struck me as being result-oriented jurisprudence, that you are saying this result is good, so here's all these different ways that you can apply to this scenario to work backwards and get the result that you want. And it concerned me because you know, we have statements that one of which I recited when I was sworn in, that result-oriented justice is government of men, not of law, directly contrary to the concept of rule of law. And so how do I get around, tell me how, in good conscience, I can take a result that I may agree with and work backwards?
Well, you know, I think that you have to look at the purpose of that underlying rule. I think what we're trying to get at is these rules were created for a purpose, and that purpose was to avoid unreasonable restraints on alienability. And so I think you're not necessarily trying to find a way to fashion in order to achieve that end result, but you're trying to look at the purpose of the rule when you're applying that rule, and you can see that that purpose is not served here, and so you don't have to apply.
That's kind of a substance over form kind of argument. But wouldn't that also concede my first question, which is that the form of the rule cuts against your argument?
Well,
And so that's why you have to make a purpose argument. I mean, if on the face of the rule it supported your claim, you wouldn't need
Sure.
to go to the purpose of the rule.
and I understand that the black letter of this rule against perpetuities and those rigid classifications of future interests, that interest is easily considered a springing executory interest. And I understand what Professor Pierce had indicated in his amicus brief that really is technically a springing executory interest if you don't determine that the interest is vested. I think you could avoid having to call that a springing executory interest, or you could call it a vested
Yeah,
springing.
your arguments all, you can correct me if I'm wrong, but they seem to me to fall into the category of how do we avoid applying the rule against perpetuities?
I think that's correct, Your Honor. Yes.
Reasons to avoid it.
Yes, Your Honor. I think that's probably a fair analysis. We tried to provide a roadmap and framework of every other court that's looked at this issue, how they have tried to, analyze the rule against perpetuities in light of public policy considerations in order to avoid what could be a very problematic decision.
And the first case points out why your vested argument may be suspect if adjoining storage field keeps pumping in, injecting gas, then production could last forever.
Well, if you have somebody who's storing gas and continuing to replenish that gas, yes, but I think that's a very rare scenario.
But what we look at with the rule against perpetuity is there a hypothetical case that can be posed based upon the facts as they existed on the date of this interest, in which the interest will vest later than the lives of being in 21 years. And you've got to say, yeah, you could come up with a hypothetical.
Sure, with continually pumping storage gas into facility. But I think that's part of, that's why I'm not saying that that's the perfect solution, and I think you'll see from what opposing counsel has pointed out that there are imperfections in some of these solutions, and I think also Professor Pierce had indicated in his amicus brief a workable solution, a workable framework in order to determine these rule against perpetuities issues in light of commonly accepted real estate transactions and whether or not the purpose of that rule is being served by application of the rule in this instance. I'd like to close by indicating that if these interests are voided, there are severe consequences that can occur. This has been a commonly accepted mode of or real estate ownership in the history of Kansas. Title has been determined based on these interests that the grantee received being valid, and oil has been produced based on that, bought and sold based on that, and if we overturn that, that could lead to a flood of litigation regarding breaches of warranty and warranty deeds, mineral trespass. I think the list is endless as to the kind of scenarios that could occur in the event that we determine this long-held interest has been violated or has been invalidated. And with that, I'll cede the rest of my time.
Can you just briefly summarize why the rule against perpetuities is the purpose is not being furthered by this transaction?
Yes, the purpose of the rule against perpetuity is to prohibit unreasonable restraints on the alienability of property. It's to ensure that that property can be marketable and that there's not going to be these unknown future contingencies that are hanging out there that could divest somebody of ownership. The interest that the Stoll grantees, the grantees of this deed, and the Stolls, who my clients, their successors in interest to, received are ascertainable. There's nothing that could occur that will divest their right to receive minerals once production ceases. So if you were to apply the rule, then you're going to get into what you discussed a little earlier with opposing counsel's arguments, that you're going to have these mineral interests and the surface two estates that will likely never be rejoined. You'll have the minerals severed in perpetuity, whereas with these term interests, it creates a mechanism whereby the minerals will be reunited with the surface at some point in the future, thereby promoting the marketability and promoting the alienability of the property. With that, I'll cede the rest of my time to Mr. Cole if no further questions.
Do we have any further questions? Thank you, counsel.
Please the court. My name is Ken Cole and I represent Jason Oil Company LLC. And I will be the first to admit when I filed this case, I did not anticipate this issue. That was not the reason the case was filed. As I sat here and listened to introductions from people in the gallery, I thought probably the most valuable word of advice or thoughts that I would have today is to remind those law students to save their bar exam review information. Because after 35 years of practice, that's the first place I went, once I found it, in dealing with this issue. The issue has come up in questioning here about, how the rule applies, whether it should be applied without regard to results, whether the policy behind the rule makes any difference. When I look at this issue as a fact situation where the rule, the purpose for the rule, the application for the rule is not necessary. In my simple mind, this is a vested interest. When you look at the development of case law in Kansas for severed mineral estates and those property interests that are created between the present ownership of a mineral estate and the future interest of a mineral estate, those are well-defined bubbles of property interests. That reserved mineral interest that Mr. Littler reserved entitled him to use that mineral estate without restraint, to alienate his portion, his term of the mineral interest without restraint, to develop that mineral interest. In fact, it encouraged him to develop that mineral interest without restraint. What happens then is that at a set period of time, either the date that's set in the deed or the cessation of production, which is well defined in case law in Kansas, there is a natural occurrence that happens at that time. And that is, we pass from the present interest to the future mineral interest. That's the test for a vested interest.
And that we know will occur with certainty?
Yes.
And how do we know that?
Well, first of all, we're dealing with minerals that are finite in their nature. And we're dealing with property interests that are separated by tracts. It is defined in these cases, quarter of land. The test is not whether there's any gas left under the surface of the land or whether there is any hydrocarbons left of oil under the land. The test through case law from this court is that either there's no production.
Do we have anything factually? Do we have any factual findings that it's impossible for production to continue indefinitely?
I think we have, as far as, I don't know that there's any evidence other than common practice in the industry. I mean, I don't know of anything that would suggest if you don't have a renewable resource, then it has to be exhausted. But even that is not the test. The test is not exhaustion, as is argued by the appellants. The test under the case law of this state is that there's no
we
production.
understand what terminates the term interest,
Right.
but the question is, because it can terminate, does that vest the interest? And
Because
but it doesn't have to terminate. Those things that you're talking about do not have to happen. And so
in my mind, they do have to happen. I mean, I guess we can say, in theory, but in practice, I don't know that it's ever happened.
And we don't, when we're talking about the rule against perpetuities, we don't talk about probabilities. We don't talk about best case scenario from your standpoint. We talk about a hypothetical that gives any scenario under which
But I,
it would not.
But
Now,
I
that's a rule against perpetuity. Now, we're talking, vesting is a different issue.
right. But we have to analyze it under the context of the development of oil and gas law and the property rights. And, you know, under the way that property rights have developed, under the way the court has interpreted what is cessation of production, I mean, I'd be hard pressed to say that it's not a certainty that that's going to happen. And so from my perspective, the interest is vested and becomes vested. It's well defined. Frank Littler transferred everything he held, whatever that is, whatever name we want to hang on it. He transferred all of that to the grantees and kept for himself that present mineral interest that naturally terminated in the future.
And just so I'm clear, it's vested because the grantees are certain to obtain the ownership at some time in the future.
Not only are they certain to obtain it, but we're also, which separates it from a lot of the cases that deal with rule against perpetuities, they are also certain to be those people. We've identified the person that's to receive it also. There's not a bunch of contingencies that's going to be out there saying, which goes to alienability, saying, okay, whenever these contingencies occur, who are we going to be dealing with? That's not the case here. We know who that person is, and I would suggest we know that condition is going to happen. You know, one of the things, and I know it gets back to the issue of what the result would be if the rule were to apply in the context, and that's where we're arguing here. That's where the issue here is in the context of divided mineral estates. In my brief, I think it's at page 9, it talks about the Clausen case before that was decided and reflected a decision on ownership of mineral interests and when those mineral interests pass to the future mineral interest. You can look at the decision in that case and see just how dramatic the shifting of mineral interests, economic interests, potential liabilities of producers will be if it is determined that, number one, that interest is not vested so that the rule applies, or number two, that as several other courts or all other courts have decided that we construe the rule in such a way that because of the uniqueness of the oil and gas present and future property interests, it should not be applied.
Do you have any further presentation, Counsel?
I do not.
Any more questions?
Just one quick, do you have any notion of how the Reformation provision of the statutory rule against?
You know, I don't, and we haven't, because we really didn't get into that a whole lot.
Yeah,
I'd be remiss, but I know that there's, you know, there could be some question whether it would go back and apply to this.
yeah. Well, one of the arguments I think from the other side was, hey, well, this isn't the end of the world because your side can go back and ask for reformation, and I just didn't understand how that was going to work to accomplish anything that you want to accomplish.
It will not.
Yeah. Excuse me.
Thank you. Any more questions? Thank you, Counsel. We thank all of you for your arguments this morning. Court will take this matter under advisement at this time.